Well, good morning. Um, I understand that a lot of you are thinking that all you really need to have is a will and a power of attorney for healthcare and a power of attorney for financial matters. Most of the time, though, once I have a chance to look at the financial information that somebody brings into me, I see that a will is not the best choice. And here's why. Anytime people have a home, savings accounts, checking accounts, life insurance that they want to have to go to different beneficiaries, if they have it set up with just a will, one thing that most people are not aware of is that a will is a one-way ticket to probate court. What does that mean? Well, it means there will be a time delay because under state law, there's a minimum of 6 months that must go by once a notice to creditors has been published. And the will, first of all, the will gets to file with the probate court. That doesn't happen immediately. Then a notice to creditors is issued. 6 months must pass. And then the executor, what we now call personal representative, is free to go ahead and start administering the estate. Second, the fees that are charged in probate court, it's not the probate court that makes the money. It's the lawyer that makes the money. And let's face it, if we can avoid unnecessary legal fees, why wouldn't a family want to take advantage of that? Third, everything that goes through probate is public information. Nothing remains private. And who wants to have their affairs made known to anybody that wants to come in and just take a look? So how's the best way to avoid it? A living trust. A living trust will keep things private. It takes less time to administer a living trust. In fact, people can get started immediately on selling assets if necessary. They don't have to wait for a court order to get that done. And then when it's ready to distribute, they're able to do so. We still like to have a notice to creditors issued, and creditors have 6 months within which to file their notice of claim against the trustee of a trust. However, in the vast majority of situations, family members know whether or not mom or dad have, in fact, accumulated debt that needs to be paid. In most cases, if somebody's been incapacitated for a while, that's not the case. They already know that. But, so it'll save money as well, because we charge generally about 1/2 of what the fee would have been had we handled the same assets going through probate. So, from our standpoint, a living trust makes all the sense in the world because you can save time, you can save money, and of course you get to keep things private. No one else knows about your affairs except us. And we are bound by the cloak of confidentiality. That's one of the great privileges that we lawyers and everybody that works for us have. No one gets to find out anything. So from our standpoint, those are the key differences. We hope you keep it in mind. If you'd like to learn more, then give us a call. That first call is no charge. And if we invite you and you decide you'd like to come in and see us, there's no charge for that first conference either. You shouldn't have to pay us to find out if we can help. We look forward to seeing you.